In the Karen Reed trial, if you were trying to follow it, it was difficult because they were always running over to sidebar. And one of the reasons was the judge said, I don't want you stating objections and arguing them in front of a jury. Well, here we are months after Karen Reed was acquitted, and the state, the Norfolk County District Attorney's Office especially, is not being overly cooperative in releasing those sidebars. Why? We're going to straighten it out.
You lost. And you know what you did.
Watching the Karen Reed trial sometimes was dramatic, and sometimes it was just so frustrating because they kept running over to sidebar. I'm attorney Andrew Myers. With me is California attorney Yoli Medina. How are you, Yoli?
Hello, I'm fine. How are you?
I'm good. I just remember watching the trial, and they'd go over to sidebar and the camera would go up to the fan up top. Remember that?
Yep.
So that's one of the reasons I tended to watch the Karen Reed trial more in the evening after the day was over, and I could have dinner and then sit down and watch it, because the infernal sidebars were just, there were a lot of them. I don't even know how many of them. If any of our listeners know, tell us the number. But
I looked at the fans so many times.
I know, I got so, but at least, in the evening, if you watched it back or you waited to the weekend to watch it back, you could just fast forward through all of those fan moments or fanning moments, no pun intended. And, it was a better use of my time, I'll say anyhow. Well, so now here we are all these months later, and, not only have Karen Reed's attorneys fought to get the sidebars, and they're not forthcoming. And in a few minutes, we're going to see what Alan Lally has to say. He's confused, by the way. And Corrie Hopkins.
Pretending to be confused.
I'm sorry?
Or pretending to be confused.
Oh, is that what you think?
No,
Really?
That's not what I think. It could be, but,
Okay. All right. I hadn't even thought about that. I thought, he just, wasn't really sure. He's a petition to the court. Enter a woman by the name of Corri Hopkins, and she filed a lawsuit under the Massachusetts Public Records Law to get the sidebars, and she is being resisted actively by the Norfolk County District Attorney's Office. And in our last episode, remember I said at that point I wasn't really too sure what that was all about. Well, not only did our viewers tell us, but Corri Hopkins herself reached out, and she has sent me a message putting it in chronological order, and we are going to do that. But in our last episode, we went over, her motion to get the sidebars, and so now we are going to start this episode off with the Norfolk County District Attorney's Office response to that. Now, this is the defendant, Norfolk County District Attorney's Office, opposition to plaintiff Corri Hopkins' motion for a preliminary injunction seeking to enforce the public records law. This is the response to the motion that she had filed that we went over. Defendant, the Norfolk District Attorney's Office, NDAO, respectfully, of course, submits this opposition to the plaintiff's motion for a preliminary injunction seeking to enforce the public records law. That's the motion we went over in our last episode. By this action, the plaintiff seeks to compel, through a public records request, the production of sidebar transcripts from the criminal trials in Commonwealth versus Karen Reed. Those sidebar transcripts are presently the subject of impoundment orders issued by the Norfolk Superior Court overseeing the Reed case, to which plaintiff is not a party. So what that she's not a party? She doesn't have to be a party. The Massachusetts Public Records Law, MGL Chapter 66, says anyone really can go through the process to try and get documents. If the public office is not forthcoming with the documents, they may, and it doesn't specify you only have to be a party in another case, they may file a lawsuit in the Superior Court. And that's exactly what she did. So it makes no difference. They just throw stuff out in this motion. The prosecution and the defense in the Reed case have acknowledged that the documents sought by the plaintiff's public records request are subject to these impoundment orders, which is incorrect, as we'll see in a minute. And both parties have filed motions which are currently pending in Norfolk Superior Court seeking to modify or clarify the impoundment orders regarding the trial sidebar conferences. Records subject to impoundment orders cannot be obtained through a public records request. For the reasons set forth below, plaintiff has failed to meet her burden of proof, and the motion should be denied. So now this is all background that I know that our viewers know all of this. We're not going to go through the whole Karen Reed case.
A preliminary injunction is inappropriate here, and here's why, according to the Commonwealth. A preliminary injunction is issued to preserve the status quo pending the outcome of litigation, and they cite a case. Rather than preserve the status quo, the preliminary injunction sought by plaintiff requires affirmative action that will grant her ultimate relief she requests in her complaint.
What they're trying to say here is that a preliminary injunction is to keep things the way they were. That's the status quo. What they're saying incorrectly here is that the purpose of a preliminary injunction is just to freeze everything. Don't move. Don't say anything, don't do anything, see no evil, do no evil, hear no evil, just to freeze things the way they are. That's their contention. But that's not exactly true. The Commonwealth is also saying that the motion also should be denied because plaintiff fails to satisfy the requirements for an injunction. A preliminary injunction is a significant remedy that should be not granted unless the plaintiff makes a clear showing of entitlement thereto.
Well, I will say that somebody who is the public, who wants a public record, is entitled to the public record.
I would agree, and that's what MGL Chapter 66, the Public Records Law, says. You're right.
Okay, so here, the sidebar conference transcripts requested by plaintiff have been impounded by Judge Cannoni in the Reed case for good cause and are not subject to production under the Public Records Law.
One of the things that the Commonwealth is hiding behind is that, oh, well, we have to protect minors, and if there is health information, nobody wants that. You know, that's fine. I believe that both Karen Reed's attorneys and Corrie Hopkins here are saying, fine, redact the names of minors, even though it got out in the press, but redact them, health information. We know that Karen Reed had some health information that Proctor was a bully about, but I believe both Karen Reed's attorneys and Corrie Hopkins are saying, that's fine. You can redact that. You know, that's easy enough. A court clerk Jim or his staff can go through the documents and redact them. It's really not that hard. But that's what that's all about in those two footnotes. Oh, okay. So basically what they're saying is the plaintiff argues that any order compelling production of the transcripts should preclude the North Andover I've been in North Andover too long. Plaintiff argues that any order compelling production of the transcripts should preclude the Norfolk County District Attorney from charging her a fee for the transcripts. Motion at 2. And so the Commonwealth is concluding that for the foregoing reasons, the court should deny the motion. Well, that's all well and good. But let's go to Corrie Hopkins' reply, which she has already had the opportunity to do.
And so
Okay.
the plaintiff is likely to succeed on the merits, she says. And she says the April 14, 2024 order in Reed, impoundment order expired upon jury verdict. Defendant's arguments to the contrary lack merit. And there's a big old footnote. And if you want to read that, go ahead.
Sure. we skipped over a lot in the Commonwealth's motion because it just went on for 14 pages, and I don't think anybody wants us to read those. But one of the things that the Commonwealth, through the Norfolk County District Attorney's Office, had said was, oh, well, by the way, Hopkins is a lawyer down in North Carolina, and here's her bar number, as though, that would get her into trouble. Well, she's responding by saying, hey, defendant's gratuitous citation to the plaintiff's bar number, stating that the court should be aware that plaintiff is an attorney licensed in another state, has absolutely no bearing whatever on the legal issues and was included for no conceivably proper purpose and should be stricken. They're just being bullies. Defendant's efforts to intimidate the plaintiff while she exercises her constitutional and statutory rights in her personal capacity illustrate exactly why the plaintiff, and not a resident of the Commonwealth, filed this lawsuit. And that brings to mind the Ducky case. Remember the case where the guy put ducks all over town? And the Commonwealth filed a police report of, 36 pages, I think? More pages than in the accident report in the Reed case. And so, that's what Corrie Hopkins is saying here, is that, the law enforcement in the Reed case was just such a bully against a lot of people that, people in Massachusetts, and I don't know if I entirely agree with this, but she's saying, and it's true, that law enforcement was really a bully and they were just trying to intimidate people. So under the public records law, why can't she do this? So
Right. And the public records laws, my understanding, it doesn't specify what any person, quote unquote, is. Any person is any person.
yeah, absolutely. Absolutely. And you know what? Before we go on with this, I would like to show people who Corrie Hopkins is. I've talked to her since our last episode, when I acknowledged that I didn't know a whole lot about it. Reach out to us. She reached out to me right after that. We've emailed back and forth. She said that right now, for various reasons, she can't do interviews right now. Hopefully we will be able to interview her in the future, but she was interviewed by Mike Crawford, our friend on The Young Jerks. Mike was sitting in for a radio commentator in Boston who is on family leave at the moment, and he interviewed her. Now, it's a radio interview, so she wasn't there, but we put her picture in it. Here is what Corrie Hopkins told Mike during the interview about how she got into it and the positive results she had initially in other areas.
Became interested in the Karen Reed trial like a lot of other people. And I started looking into the Massachusetts public records law, and it turns out this law is incredibly favorable to citizens. As statutes go, it's very clear, and the courts are interpreting it in a way that they want sunshine on government activity. And that doesn't happen all that often. So I thought I'll take advantage of it. In the Karen Reed trial, a lot of hay had been made over the lack of a crash report completed by law enforcement in connection with the death of Officer John O'Keefe.
Remember that during the trial, Yoli, that, there was no actual crash report. I mean, how can they go after Karen Reed for backing her car into John O'Keefe? And, there wasn't even a crash report. I mean, geez, even a fender bender has a crash report. So she took it upon herself, having become very interested in the case, as have people in 80 countries that watch our humble little podcast. And she decided, hey, why not? So I thought it was interesting.
Yeah.
Mike was filling in.
I like how she says putting sunshine on the government's activities. I like that phrase.
Absolutely. So Mike Crawford was filling in for Grace Curley. She's a fantastic talk show person in Boston, and she's out on family leave right now. She'll be back. She's fine.
So I thought, everyone's bothering the state police for documents. I'll ask the Department of Transportation and see if they can give me the crash report.
See, it takes an outsider to come up with that idea. I thought that was brilliant, and I said to myself, I wish I'd have thought of that.
Right.
I submitted my request back in March. They said, no. up until the trial ended. I thought, okay, trial's over. There should be no problem to get these documents. I submitted the request again. They said no again. So I filed a lawsuit. Within, they had said no for about 5 months to the documents, and I'd asked for the crash report and some other sort of form documents and emails related to it. They said no, no, no. Within 72 hours after I filed the lawsuit, they start producing documents, dropped all of their objections, no problem turning it over.
Isn't that interesting? Isn't that interesting? So she came in from the outside, another state. It took somebody from another state to, think of a different approach. And she read our public records law, and she got results, which I was impressed with that. I was very impressed that she was able to do that. Aren't you?
Oh yeah, and sometimes that's what it takes.
Yeah.
But it shouldn't be like that with the government.
Well,
Insurance companies, I understand, but the government is a different story.
well, at least the governments that I deal with are kind of like that. Here in New England, we've always done it this way. Yep. And it's a public meeting law. And, we go into secret session now because it's all confidential. It's a personnel matter. So when I was a reporter, I faced that all the time. And it was extremely frustrating covering any governmental body, whether it was the local school board or a town council or state meetings. They go into these, executive sessions claiming it's a personnel matter. I don't know what that's doing. I don't know whether that's what they're doing in there. But anyhow, let's get back to her motion or her response to the Norfolk County District Attorney saying, no, you can't have it. No, you can't have it. Getting back to her response, defendant, again, the Norfolk County District Attorney's Office, asserts that the impoundment order did not specify an end date for the impoundment of sidebar conferences, and thus, absent an order from the Reed Court, those records remain impounded. This is wrong on its face. The order did specify an end date for the impoundment of sidebar conferences, the day when a verdict is rendered. See document 4 at 3. And as we remember, a verdict was in fact rendered on June 18th of 2025. So the order has expired, she says.
Yeah, it's self-explanatory. That's what I was thinking. It's self-explanatory as when the verdict is rendered, the order expires. That's how I read it. That's how she reads it. And that's how most people would read it. When the jury verdict is done, you get it. There should be no hems and haws about it. Even taking defendant's argument as correct, and it is not, the sidebars still must be public. If the order did not include an end date, as defendant suggests, then the order was not effective to begin with. Under Rule 8, an order of impoundment shall specify the duration of the order with a date certain for expiration of the order. So, yes, there wasn't a date certain, a specific date, but there was a date, and that is when the verdict is rendered.
Oh, absolutely. And she is citing the URIP Rule 8, and that is the Uniform Rules of Impoundment Procedure, which, she cites that. We're not going to bore our audience with going through it all. But then again, she argues, even if the order is ambiguous, and it is not, the order must be interpreted in a way that is consistent with the presumption that the public has a common law right of access to judicial documents, which extends to all materials on which a court relies in determining the litigant's substantive rights. Logically, then, the public's right of access to judicial records includes transcripts, and that makes perfect sense. And down in the footnote, let me just divert to the footnote. The public records law specifically contemplates redaction of material that would be exempt to enable the release of the remaining portions of a record. So what she's saying here is, yeah, fine. We agree. Redact the names of minors, redact personally identifiable information, redact health records if it's a health issue. Yeah, absolutely. Get out the black pen electronically. Yes, I know people. Comment down below that I said a black pen when it's all electronic. But so she's saying that's fine, but you can't hide behind that to hide the whole thing.
No, because there's no secret prosecutions in the United States. It has to be public. Second, defendant cites Fremont for the purported proposition that only the Reed Court can hear the challenge to the impoundment order. But in Fremont, both parties agreed that the protective order was still operative, and the plaintiff expressly sought to terminate it. By contrast here, plaintiff cannot challenge the Reed impoundment order because it is no longer in effect, and this court cannot modify or terminate an order that expired months ago.
Moreover, the order cannot be limited to review by only the Reed Court. The language of the order is plain. The sidebars will be impounded until a verdict is rendered. In other words, the order is unambiguous. It's very clear. So, I mean, she goes on to state some really basic principles of construction, just basically saying there's no reason to not release these transcripts.
She goes on to say, similarly, defendants claim that plaintiff publicly admitted that defendant is correct is absurd on its face. Plaintiff asks the court to interpret the order as a matter of law. Defendant's attempt to extract a concession about the order's legal import from a social media post with a character limit, again, highlights the lack of legal authority for defendant's position.
Yeah, and what she's talking about there is she has an active social media presence, and they misinterpret it. I mean, a lot of times things are said and it's a summary or it's pulled out of context, and that's what she's saying happened here. And then Corrie Hopkins goes on to say, fifth, defendant's suggestion that plaintiff is attempting to circumvent an order is intentionally misleading at best. Plaintiff and the public waited for several months for the Reed Court to decide Ms. Reed's motion in the Reed case in the hopes that a separate legal action would not be necessary to vindicate their constitutional rights, which are violated every day that the sidebars are withheld. Rather than sitting on those rights, plaintiff filed this lawsuit. Well, she had every right to. Absolutely. And I don't know. I want to ask our viewers before we go any further, why do you think the Commonwealth by and through the Norfolk County District Attorney's Office is fighting so hard to keep from releasing those sidebars? Why are they fighting so hard? Why don't they just release them? Now, I have my own ideas, which I may or may not share at the end of this episode, but why do they not want to release those?
Yeah, and risk, looking so terrible, so horrible in the public eye that they don't want to release public records that should be public because there are no secret prosecutions. Why would they risk that? Why? Why would they try to make excuses or delay the release of those transcripts? I don't understand.
What's in there?
Yeah, I mean, come on.
What's in there? I mean, one of the things that was said was that, there may be information that shows that they did know a lot about what Michael Proctor was up to. I mean, now we have learned through an order by Judge Krupp down in a footnote that there may be an impact through some of the things that Michael Proctor said and did to 19 other cases. Mark Bederow chimed in when we said that and said, no, 20, because it might potentially involve the Aiden Carney cases. And so, the judge said, Judge Cannoni had said that she looked through the materials and there was nothing prejudicial in there. There was nothing. Well, now Judge Krupp looks at him and says, yes, it could affect 19 cases. So why are they hiding it? Why are they hiding it? Anybody from the district attorney's office wants to call me and tell me, you know where to get me. You know my email.
Okay, so she goes on to say, a constitutional violation is irreparable harm. Under Massachusetts precedent, an alleged violation of constitutional rights is per se irreparable harm for the purpose of a preliminary injunction. Defendant ignores this black letter law and asserts that plaintiff fails to identify any possible harm that would occur if the records are withheld. Defendant's argument lacks merit. Absolutely.
And so that is her opposition to what the district attorney was trying to say, why they don't have to release the documents. Now, Like I said earlier, in the previous episode, I had acknowledged that we have gone so deep into the Karen Reed case that I didn't notice that this all sprung up very recently. And so Corrie Hopkins herself responded to me and sent me a really nice email. And she said, Andrew, I would like to do an interview with you, but I really can't right now. I'm not able to do that right now. But she sent me a follow-up email and gave me a timeline of all of this. And I'm going to do my best to read it. This is an email from Corrie Hopkins to me. Good morning, Andrew. In my opinion, my reply brief, which we just looked at, and affidavit are the most interesting parts of all of these filings, particularly footnote 1, which we looked at. Here is a quick timeline of recent events. September 25th, I filed my sidebar lawsuit against the Norfolk County District Attorney Office, including a motion for preliminary injunction seeking to compel production of the sidebars. We read that. October 22nd, the Norfolk County District Attorney gets an extension of time to respond, including because it anticipates filing a motion with the court in the Reed case seeking to clarify the status of the orders of impoundment in that matter. And we're going to read that in a minute. Just not word for word, but the stuff that's really important. Early November, I asked Norfolk County District Attorney why their anticipated Reed sidebars motion still has not appeared on the Reed docket. Norfolk County District Attorney tells me that it was filed in Reed on October 28th, but had not shown up yet. Norfolk County District Attorney will not give me a copy of that motion until they serve me with their opposition brief. So that stuff's on there now. It mysteriously appeared, I believe, November 10th. It mysteriously appeared. November 4th of 2025, I call the clerk's office to get a copy of the alleged Reed sidebars motion. They tell me they cannot give any information out about the Reed case. November 7th, Friday evening, the district attorney serves their opposition brief and affidavit on me via email. This alleged Reed sidebars motion is still not on the Reed docket at this time. It has now mysteriously appeared. November 10th, before 8 a.m. on Monday, I file on the docket and serve on the district attorney, 1, the opposition brief and affidavit, and 2, my reply brief. Because I served the district attorney via email, they were notified that my reply brief calls out the fact that there is no Reed sidebar motion on that Reed article. And then finally, on November 10th, around 11 a.m. on Monday, the district attorney scrambles and files the Reed sidebars motion on the Reed docket. Like I said, and despite having told my judge that they filed it almost 2 weeks ago. So they said they filed it. They didn't get around to doing it until later. So query whether the district attorney would ever have asked the Reed court to address the sidebars issue if I had not called them out in my reply brief. Even though I submitted the opposition brief affidavit and the reply brief affidavit early on Monday, the court has not accepted those filings on the public docket. They did finally. But so that's Corrie Hopkins' email to me, trying to put everything into context. So they're playing fast and furious with some of the documents. Things are filed and they don't appear for a long time. It's amazing that these things happen, don't you think?
It is. It's frustrating. For me, it's a pet peeve of just public information not being public. And there's exceptions for sure, but when it's just overboard, my high school civics class, we had a
Yeah.
project where we went to the court and my teacher had said, this is the great thing about living in the United States is that you have access to public records. And back then, of course, it was paper. So we had a project to go to the court and look up a case and get the records and look at them. And it was like, okay, so this is what there was no redactions, there was no, sealing, it was just a simple educational thing. And it should be that way. Well, I know there's exceptions, but seriously, look at what's happening in Massachusetts. It should be way more transparent than they're making it.
But Corrie Hopkins is not allowing her experiences on this issue to deter her.
Right.
She told Mike Crawford she's still going and explained some other efforts that she is making going forward.
Yeah, I requested the same crash reports. And by the way, DOT had never actually gave the crash report that I was looking for. I haven't found it, so I asked for it from the state police, and I asked for a lot of emails related to former Trooper Proctor and Detective Lieutenant Tully in connection with Karen Reed's case.
Wow. I hope you keep us all updated. And again, people can follow you on Twitter and X. I'm sure you're going to be dropping all that information when you receive it from the Mass State Police as well on Twitter and X.
Of course, I want everyone to be able to take advantage of it.
So this isn't going away anytime soon. This is not going away anytime soon. So interestingly, as we know, because we read the Reed attorney's motion that was filed back at the end of July 30th, they wanted the transcripts released. That motion to have the transcripts released went nowhere. It's still sitting there. I mean, that was July 30th, the middle of the summer. We're all having cookouts in the backyard, going to the beach. Now, here we are, almost Thanksgiving as we do this episode, thinking about not barbecues in the backyard, but turkey and our relatives and all that good stuff. Still hasn't been acted on. Still has not been acted on. And one of the things that's kind of sort of interesting about that is that old Adam Lally filed a motion for clarification. What am I supposed to do? This is a motion that was filed by Adam Lally. Motion seeking clarification regarding sidebar transcripts impoundment. Now comes the Commonwealth and seeks clarification from this honorable court in regard to the court's order of impoundment of sidebar conferences and juror names. The Norfolk District Attorney's Office, the good old NDAO, has received numerous public records requests for sidebar conferences related to this matter. The NDAO, consistent with the court's orders related to impoundment, has withheld production of said materials and is now subject to civil suit related to such withholding. The interesting thing about this, to me anyhow, is he says there have been numerous public records requests. Well, Mass General Law, Chapter 66, the public records law, requires that they give them this stuff within 15 days. So I'm just wondering, how long has it been since these public records requests came in and nobody before thought, oh, geez, if they didn't understand it, which I'm skeptical of, okay, I'm a skeptic, but if they've been holding on to these and not responding, they waited until Corrie Hopkins kind of kicked them in the butt, really?
As a result of this order, the NDAO requested and received transcripts of the sidebar conferences that occurred during the first trial. So the NDA does have the transcripts of the sidebars in the first trial.
And that would seem to me to say that it doesn't explicitly say it, but I think that says that they have all the transcripts of the sidebar conferences from the first trial. I think that's what he's saying. That's pertinent because in a minute we're going to see that they apparently don't have them all from the second trial. On June 18th, 2025, that was the day of the final verdict in Trial 2 for Karen Reed, the court issued a further order of impoundment. The court found good cause existed to impound the list identifying the names of impaneled jurors. That's fine. Nobody wants to endanger the jurors. That's a side issue. I think everybody agrees to that. We don't want to, unless the jurors may, after a trial, come out as they did and speak to reporters, speak to podcasters, but that's their election. A lot of jurors don't want that. It's an imposition. You have to be away from your family for days. You're away from your job. And so, they don't want the imposition of having the press, banging on their door. That's fine. Even as a former reporter, I'll go along with that and say, okay, the court ordered the juror list be impounded, set to expire 10 days from the date of issuance. On June 26, 2025, the court issued an order to extend June 18, 2025, impoundment order, paper 728. In that order, the court stated that the court finds that good cause exists to extend the impoundment order dated June 16th and until and unless otherwise ordered by the court. So that applies to the identification of the jurors. In my view, the Norfolk County District Attorney's Office can't hide behind that particular specific order and say, we can't release all, we don't have to release all of it.
Yeah, that's not even the order in question.
Right.
It goes further to say, on July 30th, 2025, the court received and docketed defendant Karen Reed's motion for relief from April 14, 2024, ordered to impound sidebar conferences. This motion was filed by counsel who is not an attorney of record in this state. The motion seeks release of sidebar conferences that occurred during either of the two trials in this case, and any pretrial sidebar conferences dealing with evidentiary issues from its prior order of impoundment, except as to the identity of jurors. No action has been taken by the court on this motion. Of note, the NDAO is in possession of 12 transcripts from the second trial. All of these transcripts contain sidebar conferences.
Now, wait a minute. Let's go backwards to something you just read a minute ago. A minute ago, you just read this that says the Norfolk District Attorney's Office requested and received transcripts of the sidebar conferences that occurred during the first trial. So I read that to mean they have them all. But now what you just read right here says, oh, wait a minute, we only have 12 of them from the second trial. Oh, well, wait a minute, where'd they go? Where'd they go?
The court reporter is key to this. I mean, she has to have them.
Yeah, but I think the court reporters themselves are not in the queue to. They're
Really?
excellent. You can't practice law without good transcriptionists and court reporters. But I don't think they're the ones that are the bad guys here. They just do that job, and they provide the transcripts over to either the lawyers or the court or whoever. So they do an excellent but perfunctory task.
But they maintain the transcript. I mean, they would
Yes.
have copies of the transcript.
Absolutely. Yeah, I agree with that. Absolutely. Yeah.
On September 25th, 2025, the individual making the public records request from September 10th filed a civil complaint in Suffolk Superior Court against the NDAO, seeking, among other monetary measures, a court order to produce the sidebar transcripts.
Wherefore, the Commonwealth respectfully seeks from this court an order of clarification as to the status of impoundment of transcripts of sidebar conferences in this matter. Signed, Adam Lally.
My question is, does he not believe that the order expired when the verdict was rendered?
I think they're just doing everything they can to, and I've used it in other contexts, throw logs under the legs of people that want the truth. And one of the things that I had a question about is this doesn't even look like a normal order. I mean, a normal motion to me. I mean, it's single spaced and it uses, not that there's anything wrong with using a different font, but I don't know. I was always under the understanding that you double space stuff that goes to the court, except for quotes and discovery and things like that. But I don't know. I don't know. That's just a little bit odd. I thought the context of that motion and the form of the motion were just a little odd. So Alan Lally, apparently he's gotten all of these requests and he's been sitting on them, throwing them in the drawer, just like he's been throwing, the warrants that were issued in the Walsh case. He's just been ignoring that. Apparently, 6 warrants were issued by Michael Proctor in the Brian Walsh case, and Adam Lally sat in the court and said, well, I've only got the returns from 1.5. Well, did you ever follow up? Well, not really. Well, what's your policy? We don't really have a policy. So I don't know. It's not a good look for the Commonwealth. It's really not a good look for the Commonwealth. And the other thing is we have collaborated before with Alexis Room, and here is what she had to say about this whole thing.
Longer and longer, they continue to play keep away. with these transcripts, the more curious the public is going to be. And more people and more attorneys are going to do the same thing that Corrie Hopkins is doing. And then what are you going to do? So you might as well give up the goods, man. Give it up. Because if there wasn't anything to hide, you would just release it. What's the big deal? What's the big deal? She's freed anyways, right? The trial's over. Case closed. In your opinion, you still believe Karen Read is guilty, even though she was found not guilty. So what do you have to honestly lose? You have to wonder.
I thought that summed it up really well. I mean, I always ask you, what's your closing thought? I mean, that's her closing thought. And I think, I think she summed it up really well.
I that's my closing thought, what she said. And it's so true that people will speculate.
Yeah, they will. And why are they fighting so hard to not release the transcripts? I mean, for gosh sakes, it's been since mid-July. And like I said before, we're all now going into the holiday season and they still haven't been released. And Adam Lally saying, well, I don't know. What am I supposed to do? So,
And the reality is if Karen Read had filed an appeal, she would be entitled to those transcripts by a certain time in order to designate the record. And they would have to be available. There would be no problem with her getting those transcripts. At least there shouldn't be. And so because she was found not guilty, now Lally is confused about the order of impoundment of those transcripts when the order says that the order will expire when a verdict is rendered. Like,
yeah,
what
absolutely.
is okay? Does he not understand that?
Apparently not. So, do you remember in our last episode or a couple of episodes ago, we had Mark Bederow on the panel, and one of the things that he said about the whole mess with Michael Proctor's, phone stuff, the data dump that went all the way back to 2023, he said what the Commonwealth ought to do is take all of this Proctor stuff and push it to the middle of the table and say, here it is. Well, our first commenter this week addressed that, and here's what they said. They said, if you're going to push all of the Proctor crap to the middle of the table, you're going to need a bigger table. So
Well, probably.
I put Jaws up there because that's where that quote comes from. People love that. People love that quote. You're going to need a bigger boat, or you're going to need a bigger whatever. So, all right, that's number 5. You want to take the evens?
I'll take the evens. This is from, it looks like 1 hour, 88:33. If the O'Keefes were able to leave their revenge aside, they would see they have more probabilities of winning a judgment going against Proctor. Especially now, before everybody else sues him, he has to sell his properties and ends in bankruptcy. That they won't have a way to get anything out of him.
Well, yeah, I mean, the O'Keefes went after Karen Read and the 2 bars. Now, motion is pending and hasn't been filed officially to bring in all these other people. And the picture you see on the lower left-hand side, that's the people they're talking about bringing in. And whether the court allows it or not, we don't know. Number 3 from Buff Soldier. Why is Yuri not on the carpet yet? He was Proctor's first-line supervisor, and he was on the, what's that word? He was watching those text messages. He was in the chain of those text messages. I don't know what that word is, but that's what is meant here. His arrogant butt needs to be on the carpet. I would agree with that. I think we've talked about that before, haven't we?
Yeah.
Oh, he was on a lot of those text messages. That's what that is. That the P should have been an O. Okay. Thank you, Buff. Sorry.
Jazzy Cat 55. Thank you for having Attorney Bederow on. Transparency is so vital in our judicial system. Discovery shouldn't be a battle. Why does Massachusetts draw things out so long? Very frustrating to watch and hear about these delays and hide-and-seek games. Where is the professionalism in the DA's office and police forces in Massachusetts? They may need to hire a PR firm to help them gain back the trust and confidence from their citizens.
Oh boy, I don't know if the best PR firm on Madison Avenue in New York with a staff of 100 people can fix this. I don't know. I mean, it's a great comment. It's a great comment, but it goes beyond PR. I mean, PR is great, but I mean, the substance here is just that they're hiding stuff. The sidebars themselves, I mean, okay, we need sidebars, but there were so many of them in the Reed trial, the attorneys weren't allowed to make objections and state, just basic, in my experience doing jury trials in Massachusetts, you just say one word. You say objection hearsay or objection relevance. Just one word. The judges instruct you one word. The judge understands, they wouldn't be on the bench if they didn't understand, and they make their ruling. Now, if there is something that really requires more analysis, sure, you go over and do a sidebar. But the number of sidebars in this case was beyond excessive. Okay, so now we have Carrie Berry's mom. She's a regular here. Carrie Berry's mom, 7855, says, I know that you have issues with the broad brush of corruption, and you are right, but the public has lost trust, and hiding things only makes it worse. Sometimes the appearance of impropriety does more damage than an actual impropriety. It erodes trust and then becomes harder to fix. And I would agree with that comment. And I think you and I went back and forth on this very issue in the last episode, didn't we?
Yeah, and it does. Attorneys are always told to avoid the appearance of impropriety. At least in California, that's something that you have to worry about, is the appearance of impropriety. And it is important. I mean, sometimes you can't avoid it. You're not doing anything inappropriate, but it looks like it could be inappropriate. But then those are when you explain. But here, it's too much. There's too much hiding of information. And she's found not guilty, for crying out loud. There is no appeal. There's no appeal here.
No, you're right. There are still a lot of people out there that are guilters. There are still a lot of people out there. If you read our comments, she was guilty. Well, I don't know. But getting back to the point of this, though, I mean, I have said before, and I'll continue to say that, I've had a law license in Massachusetts for over 30 years. I have tried cases in the courts, and my experiences have been very relatively good. I have been in front of judges that I had a tremendous amount of respect in. It's true, early in my career, I did some criminal litigation. Now I tend to do 98% civil litigation, but it's the same judges, generally speaking, and I have had very positive results myself. But the point that this commenter is saying, notwithstanding your good results, Attorney Myers, the fact that there are so many serious questions in this case blemishes the entire system, and that's sad. That is sad, because I've always said the entire system doesn't deserve to be besmirched, but I don't know. Maybe I should give up on making that statement at the end of every episode, but Yoli, I lied. What are your closing thoughts?
Well, it's again, transparency. That is what the government is supposed to promote. They're supposed to allow. The presumption has to be transparency over any exception regarding privacy issues, sensitive issues, things like that, where there's a justification to redact or keep private, minors, things like that, personal information. But those are things that you can redact. I understand. I even understand some photographs from crime scenes that might invade someone's privacy, but it should always favor transparency. And if there's nobody objecting to awful crime photos, then they're public. But every state has an exception as to why certain things can be withheld, and so these statutes need to be more open and have less exceptions, and those exceptions need to be honored and not read in an overbroad way.
I agree, 100%. Couldn't agree more. Hey, this week we are up to 37,000 subscribers. And so let's have Hank and Lucky and the judge tell you how easy it is to subscribe to this channel.
You pay for a subscription?
I do not.
Ask it differently. I'm going to allow that.
Well, you know now because you follow. You pay for a subscription?
I do not.
Did you get one for free?
Yes. I was not paying to any social media.
All right, Mr. Brennan.
Sorry, I have just a few more questions.
It's denied.
I was not paying to any social media.
Okay.
It's free. We don't sell merch. We don't run ads. I have been approached now at this point by a number of different companies that want to run ads. Nope, we don't run ads. We don't sell merch. We don't ask you for money or any of that stuff. All we ask you is to do something that is free, and that is to go down in the corner there and subscribe. What should we use for an emoji for people that have been with us for this entire episode? Do you have any ideas?
Before we go to that, you didn't say what your last thoughts are.
Oh, well, I just can't believe that they're dragging their feet on this. I mean, it has been months. What's in there? I would like to ask our, and good, you got me. But I would like to ask our viewers, why do you think they're dragging their feet? Why do you think that they're hiding things? I said earlier on, I did have some thoughts, and my thoughts are that there's all kinds of stuff in there. We already know that Judge Cannoni had said that there had been a review of the Proctor materials and the other federal materials, and there's nothing bad in there. There's nothing controversial in there. Even Judge Krupp, who appeared rather controversial and very reserved initially, even he said there's material in here that could potentially impact 19 other cases. And of course, Attorney Bederow said, wait, what about the Turtle Boy cases? So it's 20. So I'm saying that can't be the only eyebrow-raising moment in those transcripts. That can't be the only thing in all of those transcripts. There were so many sidebars in that trial. This can't be the only thing that's a little bit shady. There's got to be a lot. And I think that my opinion, and it's only my opinion and my speculation, is there's a lot of shady stuff in those sidebars. And that's why the Reed attorneys filed to get them way back in July. So I certainly hope that Corrie gets that stuff, and as she told Mike on the Grace Curley show, that she shares it with everybody. I think she's doing God's work. I really do. So that's my closing thought. That's my closing thought. And
Now for the emoji.
yeah,
I want to say ghost to be transparent, like something, but I don't know what kind of transparent emoji.
a ghost.
A ghost.
I think that's perfect. A ghost. Yeah, I'm sure they still have the ghost emojis out from Halloween, so that's fine. That's fine. Okay. Be nice, please, in the comments section. We like to be a cut above the tunnel channels. We like to, I got excoriated in one comment this week, but we're not going to go down there. We like to consider that our viewers are a cut above others, and don't just call somebody a name in the comments. Tell us why you feel the way you do. Disagree with me all you want. That's fine. But tell me why. Give me facts. Give me law. Give me something that makes me see that, you disagree. We put comments in the comment section all the time that disagree. But, okay. Have a good one. If you don't watch us before Thanksgiving, which is still a couple of weeks away, have a good one. Have a good weekend. Be nice. Be well. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.